Similar to conciliation officer, there is a board of conciliation which is established by the state wherever necessary. Now, coming to the outcome of conciliation process. So, whenever a conciliation process is conducted, he is under the duty to report it to appropriate government. So, reporting is done under two different circumstances. Sometimes the conciliation officer succeeds in getting a settlement of a dispute. In that case, he has to send a memorandum of settlement along with the explanations. Sometimes conciliation officer or board of conciliation fail to come out with a settlement. Then they have to send an authority, it's a reference to other authorities. So, he has to report the failure along with the reference. So, these are the contents of the report. So, when it comes to failure report, the contents are as follows, that is, he has to ascertain the facts and circumstances relating to the dispute, steps taken to bring the settlement, full statement of facts and circumstances, and finally and very importantly, the reasons in his opinion for the reasons for failure to come out with a settlement. And successful report contains memorandum of settlement along with the report of the conciliation officer. Another mechanism which tries to resolve a dispute is grievance redressal machinery. Now, this machinery it's an on-site machinery which functions in the industry, comprising of workers and the employer in equal number, and the chairman of this machinery is either employer representative or the workman representative on a rotational basis. And this try to resolve a dispute at the instance itself without wasting much time. This process was inserted into Industrial Disputes Act through 2010 amendment. The composition would be that equal in number as I mentioned, and one important thing which I want to mention is that the woman should form at least 50% of the representation. And when the grievance redressal mechanism comes into function, the dispute is referred to the committee, the decision of the committee is appealable, and from the committee the decision goes to employer in appeal and his decision becomes final. So, from cooperative method let us move on to preventive methods. Now, here preventive methods has got certain advantages, like it saves the cordial relationship. The moment you prevent a dispute, you are actually avoiding a relationship from spoiling. So, therefore, prevention is better than resolution of a dispute, and the authority which is being given an authority to prevent a dispute is works committee, and this works committee is supposed to promote measures for securing and preserving good relations between the parties, and it also has to make series of comments on the important matters concerning the workers and the employer. Now, these comments, even though they are not binding on the employer, but definitely it makes the employer to think about those situations. This duties of the works committee, the problem with the works committee is that the decision of the works committee is not binding on the employer. This is the major drawback. Second drawback is balance of power is in favor of employer, because works committee always has employer's representative as the chairman. And lastly, the trade unions do hardly cooperate with this works committee, as they feel that it is actually eating into their jobs, eating into their functions, making the presence of trade union redundant. That is the reason why they consider it as a competitor rather than an associate. Then coming to the last style of resolution of dispute, adversarial methods. Now, here in this adversarial method, there is a labor court, industrial tribunal, national tribunal, and finally arbitration. But anyway, the caveat that we need to have before going through this discussion is that adversarial method is the least preferred method when it comes to maintaining industrial relations. So, labor court deals with the disputes falling under the second schedule. It takes up disputes connected with standing orders, interpretation of standing orders, matters concerning the discharge and dismissal of a workman, and a district judge, a person who is qualified to be a district judge, could preside over the labor court. Industrial tribunal deals with the disputes falling under second and third schedule both, and it can take up mode of payment of compensation, it can take up wage fixation disputes, etc. So, this is how the qualification is being prescribed under the adversarial authorities. Labor court, the jurisdiction is schedule 2 and the authority should be district judge, qualified to be district judge or high court judge. Industrial tribunal, it takes up the disputes falling under second and third schedule, and it is going to deal with district judge, the qualification is going to be district judge or of a high court judge. National tribunal can deal with any kind of disputes, but only high court judge can be preside over it, and the dispute has to be of a national importance. If you look into the powers and functions of the adjudicatory authorities, they do enjoy series of powers and functions. They have a power, or in a way we can call it as a right to enter any premises for the purpose of conducting inquiry. They also enjoy the powers of civil court. So, other important powers are enforcing attendance of any witness, examination on oath, compelling for the production of documents, compelling for production of material objects, issuing commissions for examination of witness, all other powers of the court enjoyed during the judicial proceedings. Coming to the last authority, arbitration. Arbitration is an authority created by the parties themselves. So, broadly we can consider him as a private judge who is trying to resolve a dispute between the parties by pronouncing an award. He is a private judge because he is appointed by the parties themselves. Here the state has got no role to play, except it has got a right to be intimated. Other than that, it is completely the parties who control the proceedings of arbitration. There are few prerequisite requirements are there. Number 1, application. Number 2, written agreement, which is popularly called as arbitration agreement, and then the arbitration agreement must possess the name of the arbitrator. So, when you look into the outcome of these proceedings, there are two major outcomes of these proceedings, that is, one is award, the other one is settlement. Now, if you take award into consideration, the adversarial systems, that is labor court, industrial tribunal, national tribunal, arbitration, they end with award. So, therefore, it is a final or interim determination of an industrial dispute by any of these authorities. And once the award is pronounced, the award is produced before the appropriate government for its enforcement. The other outcome is settlement. The settlement is the outcome of cooperative methods like conciliation officer and board of conciliation. So, when this person takes the matter into consideration, the outcome would be a settlement arrived at by the parties. Please remember, it is arrived at by the parties with the assistance of the conciliator. So, this is what happens with the outcome of conciliation. And there are two kinds of settlements. Number 1, that is settlement during conciliation proceedings. The other one is settlement outside or other than conciliation proceedings. So, here we took up a basic discussion on what is the right to access to justice of our laborers, but during the discussion we have found that there is a speedy method process adopted by the legislatures whenever the dispute is concerned with the workman and the employer. But not to forget that there is a selfish interest in this, if I may permit it to say so, because protecting national economy, national interest being the paramount consideration, indirectly workers are getting the benefit of this speedy disposal of system. Thank you very much.